This could be the most important case in a generation in terms of election law. I want to bring you up to speed on what could be the most significant election law case in recent history. That is Judicial Watch's lawsuit in Illinois on behalf of presidential electors and Congressman Mike Bost, who are suing Illinois because in that state they count ballots that arrive for up to 14 days after election. And rather than just adjudicate the case as has been brought by Judicial Watch's attorneys, the court there said that the candidate has no right, no standing to pursue his claim in court. So we appealed, we lost the appeal, although one of the appellate judges agreed, of course, the person has standing. And then we appealed that to the Supreme Court. And the Supreme Court a few weeks ago held an oral argument in which Judicial Watch's legal team presented important arguments on the issue of standing for candidates on this key election law matter. We compiled a nice video to describe the issue legally for you in a way that I think, I suspect you'll be able to understand it. Let's play the video.
The Supreme Court of the United States is about to hear a landmark case that could reshape how elections are run nationwide. Judicial Watch is challenging an Illinois law that allows the counting of mail-in ballots that arrive up to 14 days after Election Day. That's 2 weeks beyond the date set by federal law. Even ballots that arrive without a postmark can be counted. Federal law says the first Tuesday after the first Monday in November of every even-numbered year is Election Day for federal elections. Extending the counting of ballots doesn't just run counter to federal law, it invites voter fraud and undermines voter confidence. Judicial Watch argues that Illinois' law violates federal law and threatens election integrity. In addition, we argue candidates running for office should be able to challenge these sorts of laws in court. Until recently, it was self-evident that candidates could sue to challenge election regulations. However, 2 lower courts ruled that our clients, candidates for federal office, lack the basis to challenge Illinois' practice of counting ballots received after Election Day. Standing is the legal term for this legal right to pursue a lawsuit in court. Judicial Watch lawyers responded that candidates have an obvious interest in the lawfulness and fairness of the rules that govern the elections into which they pour their time and resources. They also have an obvious interest in ensuring that the final vote tally accurately reflects the legally valid votes cast. If a candidate can't challenge the illicit counting of ballots contrary to federal law, who can? This is the exact issue now before the Supreme Court. No other legal organization has matched Judicial Watch's record in ensuring free and fair elections. The outcome of this Supreme Court case could impact how elections are run for years to come. And you can be sure Judicial Watch will continue to fight for election integrity, because no one is above the law.
So you can see it's a pretty straightforward issue whether candidates have the right to challenge whether an election is being stolen or not by saying the law is being violated here. Votes in this case are being counted that shouldn't be counted. And I don't understand, well, I do understand why the courts in these circumstances refuse to protect that right and vindicate that right by Congressman Bost and the electors we represent. And I think it's because in 2020 you had all these courts get nervous because Trump and supporters of Trump were concerned about the way elections were run and sought to intervene and try to fix the elections and make sure they were run appropriately. And there were all sorts of standing issues that were thrown out the door that had been solid law since the time of the founding. So it was disturbing to see that, and I'm hoping the court fixes it. We were ably represented by Paul Clement, esteemed Supreme Court litigator, former Solicitor General for the United States. Solicitor General is the top lawyer in the Justice Department who represents the interests of the government to the Supreme Court, and he's been before the court well over 100 times, so he knows what he's doing. Here's some clips from his opening and closing statements to the court that day.
Illinois counts mail-in ballots received up to 2 weeks after Election Day.
Now I'm not seeing
Petitioners
anything.
contend that under
I'm just seeing
controlling
like a
federal
weird
law,
no
that is
signal
2 weeks
pump.
too long. As a result, if the petitioner's merits theory is credited, which it must be for evaluating standing, then Illinois is counting unlawful ballots. Those unlawful ballots could cost Congressman Bost the election or at least reduce his margin of victory, and he has to pay his campaign staff for 2 extra weeks. All of that means that Congressman Bost has standing 3 times over. The court below lost sight of that straightforward conclusion only by misreading this court's precedents and misperceiving candidates who pour untold time and treasure into the election and are the ones whose names are actually on the ballot as mere bystanders with a generalized grievance. That decision is not only wrong, but dangerous. It needlessly injects federal courts into the role of political prognosticators. It risks denying judicial access to minor party candidates, and it shuffles election disputes into the closest races and the worst possible context. Election disputes after the election where federal courts are in the uncomfortable position of having to pick the political winners. There is a better way, and it simply requires acknowledging that candidates have a unique, concrete, and particularized interest in the rules of the electoral road, especially those that address which ballots are going to be counted and when. At a bare minimum, a longer campaign is a more expensive campaign, and that classic pocketbook injury is sufficient to give Congressman Bost standing. There is no need to make the standing inquiry here any more complicated than that. A candidate is not a bystander in his or her own election. Their name's on the ballot, they put their lives on hold, so they have a special interest in what's on the ballot.
Yeah, this is a pretty straightforward issue, and I talked about the way the law has been distorted, not only in our case initially, but in other election law cases outside the Supreme Court after the oral argument. Let's go to that.
I think a lot of the questions from the court suggested they're concerned about a mess in the lower courts. And, in 2020, the argument was you can't sue, it's too soon. You can't sue, it's too close. And even after the election, it's too late. And I don't think the court wants to do that anymore. And I think we're seeing a direction where the court's going to say, look, the sun rises, candidates have standing, and let's just move from there.
So I was privileged to sit and watch Paul and our election law team, Russ Nobile, who you may have seen on Judicial Watch presentations before. He's one of our leading election law lawyers. He was sitting up there with Paul Clement. Really negotiate with the Supreme Court as to what the standing requirement should be and how expansive it should be. And it looked to me, sitting there, I had a good view. I was literally front and center. It looks like there could be 7 votes, as many as seven votes in our favor, including potentially Justice Kagan. And I'm not even sure if Justice Sotomayor may not support this standing, because you have groups like the ACLU and the League of Women's Voters come in and support our standing analysis as well. So we could get a sort of ideological majority, a supermajority that upholds the right of candidates to go in and sue to prevent an election from being stolen or from being illegally run in a way that undermines confidence in elections and obviously puts the candidate in a position where they have to spend extra money and be hassled in terms of dealing with this illegalities as alleged. And it's not the only case we're pursuing in this regard. We have a case in California we were representing Congressman Darrell Issa, challenging California's counting of ballots that arrived for up to 7 days after Election Day. 7 days after Election Day. You want to know why California takes so long to get its act together in terms of reporting results? One of the reasons is they count ballots and they allow ballots to arrive for up to 7 days after Election Day. In Illinois, by the way, they don't even need to be postmarked to be counted. It's that outrageous. The good news is in Mississippi, another case that we had pursued, and by the way, we're the ones who initiated this litigation in such a successful and dramatic way nationally to challenge the 20 states or the practice in 20 states, generally, specifically in 3, that allowed accounting ballots that arrive after Election Day. They do it here in D.C. You know, you can look up the rules in your own state. It's almost half the country. In Mississippi, they count ballots that arrive for up to 5 days after Election Day. We initiated litigation there that resulted in a Fifth Circuit Court of Appeals decision finding that to be unlawful. The first appellate decision finding counting ballots that arrive after Election Day to be unlawful. And why is it unlawful? Because federal law sets election days. It doesn't set election weeks or election months. And the idea that your ballot comes in after Election Day and gets counted is contrary to any sensible interpretation of federal law that sets an election day. As President Trump, whose legal position is largely concurrent with Judicial Watch's or in sync with Judicial Watch's. In fact, the Justice Department's team argued in favor of our position, or at least most of our position. Unfortunately, they were a little weak on it, but I'll leave that aside. They agree with us generally. Trump, when he was talking about this issue in an executive order, he made the point that it's like someone showing up 3 days after Election Day and going to the polls and saying they want to have their vote counted. Too late. So you need to be sure your ballots get, if you're going to mail your ballots, and we can argue about whether there should be mail-in ballots, I don't think, generally speaking, there shouldn't be, you got to make sure they get in there by Election Day. Because in my view, federal law requires it. And states that count ballots that arrive late are acting contrary to federal law. So I talked about that Fifth Circuit success. Now Mississippi is appealing it to the Supreme Court. So it could be we're in the Supreme Court not only on the standing to challenge that lawlessness, but the actual lawlessness itself. Will the Supreme Court take up Mississippi's case and decide whether Judicial Watch is correct in its application of federal election law and that counting ballots that arrive after Election Day is unlawful? Now, when will we find out about the Supreme Court's decision? Maybe as soon as next week. They could have decided it last week, but they, what they call, the lawyers call it, they relisted it for a conference on November 7th, which is a Friday. And they typically announce the results of that conference where they talk about cases they want to take up or not take up and make decisions along those lines on November 10th. Now, is it guaranteed they'll talk about it on November 7th and they don't delay it a little bit longer? No, but it could come as soon as, I say, November 10th based on the decision they make on November 7th. So we could have your Judicial Watch team 2 cases before the United States Supreme Court on this essential matter. The issue is standing and the right of candidates to challenge elections and go to court and challenge and try to stop an election from being stolen. I mean, this could be the most important case in a generation in terms of election law. And I think the left doesn't know what to do because they, at least as I point out, the ACLU, which opposes us in every other election law case, is on our side in terms of standing. And I'm convinced that the Supreme Court is going to look very skeptically at courts or at states who want to count ballots that arrive after Election Day. Because think about it. What is the standard? How long can they wait? Can they count ballots until the next election? If not, why would there be a prohibition? how do you decide how long they can count ballots for? So that's the big issue. And Judicial Watch, once again, is front and center on this core effort to ensure that elections are fair and free and run according to law in a way that guards against voter fraud and instills voter confidence. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.